Yep, she's there. Hello. Okay, I do not see that the camera, did it light up? Is it on?
Yes. She's got a huge rooms in this month and it's just been one problem. Oh, they have a piece of. And she's strong, but she. It's hard to get everything.
Yeah, there's all kinds of stuff. Oh, there's. Look at that. Okay, 6 o'clock. Yay, it worked. All right, okay. Hi, Michelle, can you hear me? Hi. Okay, I don't see any cameras on except for this computer.
And I don't think, can you hear her, since I can't.
No, I believe, I think her microphone is off. Okay, Michelle, can you unmute your mic so we can make sure we hear you?
Yes. Can you hear me?
No, but.
Oh, no. Here, maybe. Okay, I think I see the issue. Okay, let's test that again. Can you hear me now?
Okay, yes.
Yeah.
Okay. I should probably turn it back down because I thought that was the problem, and now you're very loud. Okay, give me one more second. I'll see if I can get this other system to turn on its camera. Okay. Well, hopefully it's being recorded through the Zoom meeting. If not, we'll just have our minutes. I have clicked on this other machine for it to record, but it may help if we have IT come to one of the meetings to give us training. But I'll go ahead and call the meeting to order. So I call this meeting of the Fountain County Board of Zoning and Appeals to order. Let's say the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Okay. Let's take a roll. Chris May. Here. John Allen.
Here.
Dave Filippo.
Here.
Jess Anderson is here and John Schrock is en route. And then, so let's let the record reflect that we do have a quorum present as we begin. And Michelle, do you want to say hi and introduce yourself?
Hi, Michelle Harder, legal counsel. How are you?
Doing good. Okay, so our primary agenda item today is to consider adopting the internal rules. But I did pass around a copy of the minutes from the BZA special meeting. And I don't think that we got a copy of that to everybody electronically, did we?
I didn't know I was supposed to do that stuff.
I don't think there's a supposed to yet, so, I think I will hold off on approving them until the next meeting, so you guys have a chance to review them. Is that okay? Okay. So you also have in front of you the draft rules for the filing of appeals. So we're gonna consider adopting those. They are required by state law and our local ordinance. Indiana code does say the Board of Zoning and Appeals shall adopt rules concerning the filing of appeals, the application for variances, special exceptions, and conditional uses, and the conduct of hearings. And our ordinance also refers to the board's authority to adopt rules anywhere that the ordinance is silent or ambiguous. So we've got to have this if we're gonna proceed with any clarity and good legal standing. Michelle, did you have any comments that you would like to share on the rules before I make a motion?
Well, I guess I'll answer any questions, but just generally, Jess is correct. There needs to be rules. It's kind of concerning to me that there wasn't any rules, right? Now we have to kind of catch up and get some rules on the books that are going to apply until they're either rewritten or so. I think this is just the start. We might need some other rules, but these are sort of threshold issues for what the Board of Zoning Appeals needs to do and decide. Time frame, obviously the public needs to know when they can file, and then we need to know if an appealable action has occurred. There is a little bit of a concern, I think, for at least for me, about and I think Jess addresses it here, where hey, it might not be clear that an appealable action happened. So the rules are written in a way that if there's ever sort of a gray area, or we're not sure if an appeal is appropriate, it gives the Board of Zoning Appeals discretion to hear those appeals. And the cool thing about it is you're not required, because it doesn't say shall hear, but you have discretion to hear any appeal. So it kind of allows sort of a relief valve or a catch-all provision in here, so that if something comes up and it's appropriate to hear, you can decide to hear it. And you can also decide or decline to hear it if you don't want to do that. So I like this rule because it is so flexible. I think that it will cover different situations. The one thing that there's a little note where it says still pending legal review is about publicly noticed. So I mentioned to Jess that some things are publicly noticed on the front end, right? So anytime there's a meeting, there's public notice. Anytime, arguably anyone does anything, it would be on an agenda somewhere, so the public would be noticed in some fashion. But there's going to be times, and I'm aware of some times, where there's an action that under the ordinance would be something I think the BZA could consider, but that maybe notice wasn't necessarily given. For instance, it says a decision or determination subject to BZA review. Well, what if our zoning administrator makes a decision to not enforce the ordinance? I don't know that that would be noticed, right? So notice didn't happen. And that's kind of why we have this catch-all rule, right? Where it's like, okay, well, when does the clock start running? And so there are going to be some determinations and decisions that are less clear. Most of the things are going to be publicly noticed on the front end, but some things aren't. And I tried to think about, should we change the language? Is there something we need to do here? I think leaving it just as is might work, because we do have the catch-all provision, and we know that some things aren't going to be noticed. And so if it's not noticed and the person doesn't know and isn't aware, then we can't say a deadline starts ticking. And this is consistent with other areas of the law too, right? So in the law, usually you have 30 days from a judicial decision to appeal things, but there's also times where if you didn't discover it within 30 days, there's sort of a safety net for, we can catch this later if you later discover new evidence or you later find something out. So even our trial rules are written in a way to consider the fact that new information could come to light. And so I think this makes good legal sense. Will we find in the future that, when we test the rules that maybe we want to do things differently? Who knows? But for now, this seems to be written in a way that I think will cover a good variety of situations and not let too many things in or, exclude things either. So those are just my thoughts. And if you have any questions, I'd be happy to answer them. Uh-oh, I can't hear you, Jess.
Thank you. I'm going to go ahead and make our motion. I'd like to make a motion that the BZA consider the rules packet for appeals, including the rules under the time frame for filing an appeal and guidelines for determining whether an appealable action has occurred. So I have a motion.
I'll second.
Okay. So I think it's good to look at this from two sections so that we can kind of like gear our discussion towards either of those. And the first one is just, we need to nail down with some more specificity beyond the state rule of 30 days, what we expect as the BZA for the time frame for filing an appeal. So it says here, any appeal of a permit, order, requirement, decision, or determination subject to BZA review, appealable action must be filed within 30 days of the date of the permit, order, requirement, decision, or determination is filed in the public record and publicly noticed. So you see, it takes the state code that's generally 30 days and then it narrows it down more, which is within our right to do, right, Michelle?
That's right. And we're required to do.
Required to do?
We're required to have rules that our ordinances, obviously the statute dumps a lot of things, do this by ordinance. And then the ordinance is like, do this by rule. So it's just kind of we can do anything that's not set forth in the statute or the ordinance, and we need to have rules to fill in any gaps in order to operate, right? And a lot of parts of the ordinance say over and over again, by rule, by rule, by rule, and we don't have rules. So this is our rule about time frame. And the statute, it isn't, like Jess said, isn't specific about what exactly kicks off the time frame. So that's why we need the rule. You're muted again.
I'm sorry. Okay. A permit, order, requirement, decision, or determination is not considered final, and the 30-day appeal period does not begin until the permit, order, requirement, decision, or determination has been, we have two criteria. Number one, filed with the county planning zoning office in the ordinary course of record keeping, and number two, publicly noticed in a manner reasonably calculated to inform affected parties consistent with applicable law and BZA rules. And so this is the provision that Michelle was referencing right off the bat. And I think right now we have a good level of generality in that we can go in and refine it later without cutting off anything we've done before. But I think it definitely needs more attention in the future, or we at least need to see how it plays out in practice. And then we have a little clause here that I think is important to protect citizens from like phantom actions that they wouldn't know about. If no such filing or notice exists, the board may consider appeals made in good faith that are filed within 30 days of the appellant discovering the permit, order, requirement, decision, or determination. And I think that good faith language is pretty consistent across state and even federal law, or at least in how courts hear decisions. So we don't want anything to be unfair to any of the appellants here, just because there weren't rules in place or because things weren't specific enough. So we want to make sure that we're leaving room for citizens to exercise their rights.
I have a question.
Mhm.
When the zoning board approves a permit, when does that permit become a permit in paper? I mean, if they approve it and they wait 2 or 3 weeks to get their permit, does that mean 30 days starts when that permit is issued from the courthouse? Or does that 30 days start when the zoning board says, hey, yes, you can do this?
I sure wish that the courthouse was stamping permits. Right now, the rules in Fountain County are simply, the zoning administrator, which is not actually named in the general ordinance. The zoning administrator, as far as I can tell, is only named in more specialized ordinance sections like solar. The zoning administrator is also named in state law, and they have the right to maintain their own records without any additional rules. If there are no additional rules from the county, that's where it stops. The zoning administrator maintains records of the permit. So right now, the county has no copy of any permit issued in any of the big projects going on in the county.
Well, that brings up my point though, you're saying 30 days from the permit. But that permit could have been approved and they waited, or no one knew about that permit until almost 30 days were up as well. And I know you put the good faith in there.
Right,
but
from
how-
30 days of the appellant discovering, not just a permit, but the permit order requirement decision or determination. So we leave it in there that the person gets some indication that an action has been taken that's gonna affect their use of property or, you know, affect them. And then
Should
they,
there be a line item or a list that says, after their meeting to say, this was approved, this was approved?
yeah, there is no board, it's one individual.
But, yeah, but can, as part of the Board of Appeals, can we make it a requirement that they have to give us a listing each month of approvals?
Yes, and that's on
I mean,
number.
we have that right to know that, correct?
Yeah. The number 2 on the second section
Yeah.
makes that a new requirement.
Where is the
Because-
BZA a rule-making authority?
Well, let me answer his question first. Number 2 makes that a new requirement because right now we have too much ambiguity. And we're having to basically like run an investigation with no teeth to try and even find the document, you know, for the recent appeals that were issued. So here it would say, the zoning administrator on number 2 under guidelines, or any other issuing authority must provide documentary evidence of the permit order requirement. Oh, no, it's actually in another rule.
But see, that's my,
Oh, here it is, that they would have to file it. That would be a new requirement. It's actually number 1. Any permit order requirement decision or determination has to be filed with the county. Because I went to the county and said, can I get a copy of this permit or this permit? And they're like, we don't have copies.
But that would go through the APC in order to, is this is reaching from Article 1 to Article 9. This isn't just a rule for an appeal of how we're going to 30 days, we say 30 days. Next change of command occurs and then it's 60 days. Next change of command, it's 15 days. They can change that. This is that they have to file it with the county planning in ordinary course.
So 2 things. 1, the 30-day standard is set by state law. And 2, this is not something that needs to go through the APC and commissioners because this is an internal BZA requirement of the zoning administrator so that the BZA can conduct its business. It's not a new ordinance.
oh, I agree with. I
No, I'm
agree
just
with
answering John's
Yeah.
question.
I agree with what you're saying,
Mhm.
but. At the same token, that 30 days can be used against you. As well, they say, well, we went through the appeal process, no one spoke up. it was approved by the zoning board. And the notification comes out later,
Mhm.
I'm just saying. There ought to be a clause in there that gives us some type of timestamp. To say that appeals are proper or not proper, because if someone waits 3 months and then starts complaining. I'm sorry, that's a little too late of
Mhm.
action
Mhm.
to react to.
So you're saying the board needs to have. So let's look at,
But
number,
Indiana law and what. We are required to have these things in place for due process for the citizens, and they are not there right now. So. It's like she said, she's surprised they're not there. They should have been there.
let me see if I
There's a
understand your
process.
question, John. You're saying that the board needs to have some discretion in determining whether or not the appeal is actually being made in good faith. That we can't just have the deadline going off into perpetuity, but you would want some restraint on that,
Yeah, there
Yeah.
should be a counterpoint,
yeah,
you know, it's
so,
kind of like the lemon law
yeah.
is a perfect example that you have 30
You can't
days.
just appeal like a year later.
Yeah.
So let's skip ahead to number 4 in the second section. Hang on, let's stay on track.
I'm right here on time frame, you skip down.
No, I'm gonna skip ahead to number 4 to answer John's question. Number 4 in the second section says appeals filed in good faith based on reasonable belief that an appealable action has occurred. Now, this good faith language and reasonable belief, if someone came to file an appeal a year later, they wouldn't be able to say that they're satisfying that requirement.
That's correct.
So
But-
is that the counterpoint that you mean?
Yeah, that's part of it, but. There should be a process where you have a starting point for an end point.
30-day clock has to start, but it hasn't been established yet.
And, but we, as a
We don't
group,
know.
don't know this.
Right,
I mean, I'll use Dolphin as an example,
let's not use
Yeah,
dollars.
it's
Okay.
all.
but there was a question about when a permit had been issued.
Mhm.
You know, if they were giving us a record of saying it was approved on this date, such and such, then you have a timestamp. And then that's when your bill would start.
And right now, we don't have a record, and that's.
We have no record.
Okay, I'm gonna let Michelle take a crack at the question, but let me see if I can frame it. Like in a consolidated way for her. Your question is, what do we do when there's no record of an initiation of a timestamp, and does this handle that?
That or an approval.
Yeah, okay, let me see if she can shed some light on this for us.
So that is actually, you've identified the problem, and that's where the public notice part comes in too, right? So if an action happens and we don't even know about it, we kind of have to figure out when we're going to cap that off. And so that's why we have this, if no notice or filing exists, then it's 30 days upon discovery, because these things might be hidden. And it kind of does give them a longer time frame, but it also, I mean, I also was initially concerned about, hey, this could be an infinite. What if they already built or did what they were supposed to do, and then someone comes in, can they say, hey, you can rip it down 3 years later because I didn't know about it. I just moved to the area. And I think that those sorts of things would be screened out under the permissive language of may hear an appeal. The BZA doesn't have to hear anything that's outside, unless the person makes some sort of showing of good faith and reasonableness. You would hope that if the zoning administrator or whoever makes a silly decision that isn't properly noticed or filed, gets slapped down just once, they would be better with record keeping and notice, I would hope. I don't think that we can necessarily force them to do those things by our internal rules. And that probably is something that needs to be worked on with our ordinance, because our ordinance is lacking in many respects. But right now, we're just talking about what the BZA is doing as a matter of internal rulemaking, and we can't necessarily fix those bigger problems. That's sort of a separate issue. I think given what we have to work with here, though, I mean, this is a good starting point like Jess said, we might need to tweak it a little bit if we get like a flood of way after the fact appeals and people are trying to bring up their sob stories and it's just not working. Then it would be a different story here. I mean, the record keeping thing is an issue. I'm not sure we're going to be able to solve with the BZA procedural rule for sure, but we can't not have a rule either. So it's kind of a strange situation to be in. Maybe you all can tell me. I don't know how many appeals the BZA hears annually or how often this happens, or it seems to me like there couldn't have been too many appeals because there's no procedural rules to hear them. So we might not have had that experience before. I'm not sure. But yeah, I mean, I also have the concern if we don't want it to go on into perpetuity, but that's why there's this may language and not we have to hear it. It's kind of baked in that there's discretion. Maybe someone would argue it gives the BZA too much discretion to hear a belated appeal, but the alternative is making it super restrictive and then someone can't appeal something because of crappy record keeping by the zoning administrator, and that doesn't seem very fair either. So yeah, I mean, there are some concerns. There's definitely some policy things here. Thank God I don't have to make any policy decisions, but legally, I think we're within our ability to draft these rules, and I don't think there's anything crazy here. If this ever did go to court, the court would defer to this body as long as we could articulate a justification for those rules.
Yeah, and I when I was drafting them, I really wanted for there to be like a threshold that would have to be stepped over before the whole appeal engine started to go. Because we might get something that's, a ridiculous, somebody comes in way after the fact and wants to undermine it. So that's why number one for the first thing to do is to decide whether an appealable action has occurred. So that's what you see on the heading. Guidelines for determining whether an appealable action has occurred. And we basically, in number one, say that's what this board does. The board, when an appeal is filed and there is any ambiguity or dispute about whether an appealable action has occurred, the Board of Zoning and Appeals shall first determine whether a permit, order, requirement, decision, or determination exists. And it probably needs to have a second repeat of appealable there, whether an appealable permit, order, requirement, decision, or determination exists. So then if an appeal is filed, and it meets the timing guidelines up top, including the option for them to submit it in good faith, just in case there was some shadow decision, like we know we may have, where there's ambiguity about the start date. Before the board starts compelling testimony or whatever else it is that we're going to do for an appeal, we have to begin with deciding, do we even have something here that was appealable? And so it leaves it to the discretion of the board there. Does that sort of get at your concern, John?
A little, yes, but I mean, right now, we've been very fortunate. We've had more appeals this year than we have in 5 years. But they've all been rural country landowners that were stuck in some old clauses of their property and stuff. As this develops and grows, though, complexity of it will change in time. And if we can be a step ahead of that change, I think that's better for the board in the long run. And that's where communication is more important between the two organizations.
And by that you mean between the BZA and the zoning administrator?
Yeah, from the agency, whichever how you want to word it.
Whatever.
Just having that down the road. I mean, we've watched Fountain County zoning from the infant stage up to a baby stage now. And now it's gonna become a toddler. And everyone knows toddlers are a pain in the butt, but you love them to death. And then it's gonna get teenagers, and then it's gonna be adults. It's gonna keep growing. And I think that we can't narrow our focus down. We need to make sure that we're expanding so that we can try to compete with this properly.
I think that
And you know, maybe this is the first step,
Yeah.
but if we don't have better communication down the road, it could lead to other problems.
Oh, absolutely. I think, Michelle keeps drawing our attention to the word may instead of shall. So it gives some room because it's not like it's commanding, because we may not, who knows how long any individual here will be on the board. It's not commanding future members of the board to do things a certain way. It's saying that it's basically giving the authority to begin with. Like, you know, I can say, yes, you may have another bag of chips to one of my kids, or you shall have another bag of chips. It's completely different. Like I wouldn't want to order them to do that, but if I want to set up the framework for them to exercise their autonomy, then they have to have that may language built in. And I do think that we need more, clarified rules for how permits are issued and all of that. But that is something that would have to come through the ordinance itself. So that's not something that this body would deal with. And as far as working, when you say communication, do you mean like we need to know when permits happen somehow?
It would be nice if once a month or whatever, if we select certain permits to say, hey, we would like the BZA to be notified of these types of permits.
Yeah.
You know, if someone's building a house or wanting to put a grain bin on their farm,
Mhm.
we really are not worried about that and stuff. But if we have a corporation or a nonprofit group coming in or whoever it may be, you know, those type of permits,
You think they may warrant some enhanced notice?
yes.
And I think that's definitely something we should look at. I don't know if we can fold it into this rule today,
I don't think you can right now.
but I agree with you. Having a trigger set where within whatever legal rights we have to request that we're notified and that the public gets notified also, because if people are gonna file appeals in a timely manner, they have to know about what's being filed.
Yeah.
So I think right now, what this rule does is it sets the expectation that that would be a reasonable thing to hope. It would be reasonable to hope that if a big permit went through, that a citizen could come down to the county and say, can I see a copy of this permit? And that they would have it on file. And right now, that's not in practice what's happening, but it's okay for the BZA to say, if there's no permit floating around in the county, then we don't consider there to be a permit floating around the county.
What does
You
that
know,
do?
that's our discretion. What'd you say, John?
As a body, we can't even function. There's no purpose for us to hear appeals if we don't know what and when the authority and purpose of the rules of procedure for appeals, just in my own research, is it establishes procedures for appeals, variance, and special exceptions to ensure fairness. It's the due process we've talked about all this time. But it applies to all appeals from decisions of zoning administrator, area planning commission, or other administrative officials. How can we even discuss anything if we don't know when a permit and what the permit requirements are? Like, I don't even know how
Yeah.
BZA functions, and it's.
I'm gonna defer to Michelle again and get some clarity.
I think the
Michelle,
problem,
those questions coming through?
yes, I'm listening. I
Okay.
think the problem I'm hearing is that we can put this rule in place, but there's other things that are broken. So I'm not sure what the BZA can do to fix those other things. If there's work we need to do to coordinate with other bodies or entities, but I don't know that the BZA is empowered to fix some of those problems. I agree they need to be fixed. But the BZA is just trying to set, but I understand what you're saying. It's hard to even know when a clock is ticking on either the front end or the back end when it sounds to me like we have some really bigger problems in the county with the ordinance and the whole zoning scheme where why isn't there clarity, transparency, and all of these things about what permits are being issued, what decisions are being made, what requirements there are. It's kind of scary to me that we can't get clarity on whether a permit even exists. And frankly, how are the people who are getting these permits going to rely on them if we're saying, well, we can't even prove you have one in the case of like personnel changes, for instance? Like if someone leaves, how do we know what they did or didn't do or promised? And then we're bound by an ex-employee's contractor decision. I mean, those are some scary things. I'm not sure, like I said, they're within the purview of the BZA, but definitely something the county needs to work on. And the ordinance in general, I mean, it needs some work too. I'm sure you've noticed it's very bare bones and also kind of skewed on some issues.
Yeah. The way I see to move forward best is that we have to work strictly within our authority. And our authority is just to create internal rules, and we clarify our interpretation of the ordinance. So when I see that somebody has so long to file an appeal if a permit is issued, my interpretation is that that permit has been made available to the public in some way.
Right.
So we can set that as an internal, this is what we think should happen. If there was a permit, we figure we should be able to find it.
Yeah, but we know that that's not true in every situation.
And so that's why there's an if.
And you can go get that, and
Well,
Indiana Pact.
so we say what we expect. And that's a permit order does not begin for unless these two things happen. That's what we expect. That's how we're interpreting the ordinance. But like you say, we know that in practice that isn't happening. So we can't just gaslight the county or ourselves. We have to deal with reality. The reality is handled by the following if statement. If no such filing or notice exists, the board may consider appeals, doesn't have to, may consider appeals made in good faith. So that puts the onus back on the citizen that you're doing it as soon as you heard, that are filed within 30 days of the appellant discovering the permit, order, requirement, decision, or determination. So we're saying in a perfect world, we would love that there's a little folder in the assessor's office with these permits. We assumed that when the zoning administrator was given the power to issue permits, that would be a normal way of doing business, that he would give a copy to the county. If that doesn't happen, because there may be some projects that do have a permit on file. If that doesn't happen, we have to have a way to protect the citizens' due process rights. Right now, for some decisions, we cannot, even with direct asking, figure out a start date. So we can't say to this person, well, you just noticed this stuff going in, but they had an email, back whenever, and that's when it started, because that violates their rights. So we have to have a catch-all until the ordinance advances in its specificity. When the ordinance advances in its specificity, if there's any change in the ordinance, we'll have to go back and revisit this, because we'll need to interpret the ordinance as it stands. Does that make sense?
I have another question.
Okay.
Does this allow time for notification, 30 days? Because if we don't know about a permit, we dealt with notification and who should receive it in our last one. Does 30 days give us time to notify people, and then, is it our responsibility to send notices to get those issued, or how
It
is
is
that?
It is not our responsibility, but it is covered in number 2 here of what we would anticipate would be normal business. So 1, we would anticipate that if the zoning administrator gave a permit, that he'd give the county a copy. Number 2, we would anticipate that would be publicly noticed in a manner reasonably calculated to inform anybody that's going to be affected, consistent with applicable law and BZA rules. Because you see, when the zoning ordinance got put in place, they only are legitimate if they're following the state law first. you know? Like, that's why we have to have these rules in place. So there's also state law that protects those appellants and also has reasonable expectations for how the public is notified. And if so, we have to assume that one, the county got a copy, and two, that people were made aware. We would assume that to be normal business based on how we read the ordinance. But because we know that the ordinance has ambiguity, we protect the citizens by also saying, we know that that may not happen. So if it doesn't happen, we consider it made in good faith if they're filed within 30 days of discovery. So discovery isn't filing. Discovery is receiving the information.
Oh, okay, that's the part I needed.
So we have three things that are happening with the information. One, it's being filed with the county somehow. Two, the public is being made aware. Or three, the public finds out on their own. That's how the information is getting transmitted. And I think we have it all covered with those three possibilities.
So how do we see this working? It says a permit, order, requirement, decision, or determination is not considered final. But if there's not a appeal, then it is final? I guess I don't understand. The BZA saying something's not considered final when if there's not an appeal, where does the BZA come in on this? It went through. We had a zoning change happen. And is that not considered final?
Until the BZA blesses it, basically, so we'd be.
It's-
like-
It sounds like the BZA
Until
just,
number 1 and 2 have been met.
but the BZA doesn't have to bless any.
No, and it
No.
doesn't say that the BZA does.
I see where you.
That's what I'm,
Understand.
we need rules, we need to have, because the ordinance says by rule,
Mhm.
Michelle's point, your point. But it's not considered final till,
Well, number 1 and it says has been, and then there's a colon. Number 1, and then there's an and underneath 2. So it sets
30
forward
days.
the 2 criteria for what makes the decision final. It's not sufficient that somebody sends an email somewhere and the county goes, yeah, that counts. That's a final decision. So we're saying, we're assuming that people are doing things where they let the county that they represent know and the people in the county know. And those are the 2 criteria, and it's not an either or, it's an and.
well, I
I think she's
understand, I'm
saying
saying.
it is not final in the 30 day until, like, we don't have the authority to say a permit isn't final. A permit can be final by
It doesn't say that it is or isn't.
your appeal. No, it says. a
It says
permit
that the BZA will not
considered
consider
final.
it final.
No, here, up here. A permit is not considered final. It just might be tweaked the language. A permit is not considered final until all these other things. We're not the agency that's going to say that, like the
We are.
zoning administrator issued the permit based on all that criteria they decide.
Yeah, but the BZA won't consider it final unless he's done what's reasonably expected in
So you're
normal
saying
business.
any permit now that goes through our zoning person group, whatever. It will all have to be subject to, but I'm saying there's no language. Like, there's no language
Or
in zoning ordinance, like the ordinance, like, I don't know if that's enforceable as.
Okay.
Even I see what you're saying as a rule, but.
And that's what, I'm not trying to
That's
say no,
enforceable.
I'm saying is I'm just trying to. Walk down the road and say, okay, it's not considered final.
Right.
Cause they're not doing how, well, but that's how the commissioners liked it, that's what they installed way back when, so.
They give that authority to the zoning.
They
person,
gave,
right.
they gave that to
Right.
that person. It's not a whether I like it or not, but they did,
Right,
and then that went into the ordinance, and then that's how they're doing it. It's not a thing of that, I'm just wondering, is this the Band-Aid that needs to be stuck on
So
them?
it's not that it takes away anything from the ordinance, because the ordinance just says that the zoning administrator will issue a permit.
yeah.
It's just
We just
specifying.
make sure that, the project meets all those, that's what we do. We
Unless
don't
there's an,
say,
not
yes,
if there's not an
permit.
appeal.
That's what I mean, if within an appeal, our body just says, yes, this project did need this, yes, this project, because someone will say, hey, there's a defect in this procedure or something. They can't just randomly say, I'm gonna appeal this because I don't like it. And that's what we're saying. The zoning person has the authority to say, here's your permit. Now, someone else can come and say, hey, you didn't follow the right procedures, or this and that. That triggers an appeal.
Our board says, when we're
Yes.
hearing, we have said, we don't consider it final until it meets this.
Right,
But that's when you come to us with an appeal.
right. That's when.
When the appeal has been filed,
Mhm.
what we do here, tick A, B, C, sub A,
Yes.
sub B, sub C, I could see that.
Yes,
It's just,
Mhm.
if it meets all of the zoning,
But we do have to create a reason for the 30 days to start.
well, that person.
And that's
will
what
say,
this does.
so if
And
there
the
is a
30-day
date on the
appeal period.
permit,
Does not begin until those two criteria are met. I agree with you, though. Not considered final is probably troublesome language.
Yes.
Let's see if Michelle can give us an off the cuff, like hot take on that.
Yeah, I have some thoughts. That's a legal term of art, considered final. You know why? Because generally, in administrative law, you have to exhaust administrative remedies before you can access the courts. And also in the court system, you can't appeal a judgment or an order of the court until it's a final order. It's called the final judgment rule. So that language is often used as the magic words to say, not necessarily final in the way you all are discussing in terms of practicalities, but final for the purposes of being able to be reviewed on appeal. And that just means that the body hearing the appeal has all the information that they need in order to decide the matter. And the point here is, if these things didn't happen, then the BZA does not have what they need in order to consider an appeal. So we could massage that language a little bit, because this is not a court setting, but that's kind of where it came from. The final judgment rule is the magic language for anything that is about to be appealed. It has to be ready to be appealed with a complete record. Otherwise, it's not appealable. So final judgment and appealability are often interchangeable terms of legal art, if that makes any sense.
so if we have, hypothetically speaking, without using names of anything that may or may not occur. If Acme decision is made, if decision A is made by a body other than the planning commission, because the BZA can't hear appeals of the planning commission pursuant to the ordinance. So if a decision is made by, let's say, the zoning administrator, whoever that may be, at whatever such time. If that decision is made, the people can move forward with it. If there's a date on that permit, that's hypothetical. If there's a date on that permit, they can move forward, is what I'm hearing. But in order to hear the appeal, we're using the word final because of administrative rules. Is that correct?
Could we put in parentheses for the appeal process? Just so that it's not saying final, but if you want a final decision, this is for the appeal process only.
So,
We could just put that the decision, determination, et cetera, is not considered appealable, and the 30 window does not begin until, we could just take the word final out and put appealable. The trouble is, though, we don't want a situation where the BZA hears a matter before it's quote unquote final, and then we're told, well, you didn't have the authority to hear that because it wasn't a final decision. I mean, I guess this is another issue, right? When is it final substantively? That's got to be something that's, the way it works in the court world is both the trial courts and the appellate courts have a rule about finality, and they are overlapping, but they're written from their own perspectives. So here we need to hear from the ordinance or someone else On the other end, before appeal, what is final then, right? So we could do whatever we want as the BZA in terms of deciding appeals, but it would be great if on the other end, there was a definition for when some action became final on that side.
We remove the finality clause from this completely right now. And just leave it as, we're looking for the trigger of when the 30 days starts. So what if we just said the permit order requirement, decision or determination, the 30-day appeal period for any permit order requirement, etc., does not begin until these criteria are met. And so that way we're not asserting finality. Like maybe we need to refer that back to the APC and request language or something like that, whatever the procedure is. So we're not determining finality of a permit because the zoning administrator has the authority to decide when the permit is a permit. But we're just looking to clarify for our purposes, for the appeal purposes, when that 30-day window starts. So for now, we would set aside the finality completely.
I think that's where the tree was marking up, yeah, like when the appeal is filed. A permit, we considered a permit in our. When it comes to us,
Mhm,
when they come to us, not us looking for them,
mhm.
when that happens. When we say the word permit, that's the one that's on file with the planning office, and I'm using very truncated words.
Yeah.
What's that called, the cliff notes.
Mhm,
It's the one filed with the planning office, it's the one that's been publicly noticed, and
mhm.
I'm not trying to go and veer off.
And then
So
there's
now-
the if to handle if that doesn't happen underneath it.
And if it doesn't, then we've got it.
Mhm.
But, so now we're hoping is that that permits are publicly noticed.
Well, we know that they're not right now, so that's why with the bigger clause is underneath, if no such filing or notice exists. But we have to set a rule for
We have to have.
what we would think would be normal business. So I think it might be smart to set aside, if finality is an important word in court, then probably we need to ponder that longer and come up with something specifically for finality.
But since we don't have public notice. Happening, since no public notice exists,
Mhm,
there's never, as far as I know in Fountain County, we've never publicly noticed a permit.
right.
So then. The board can now consider appeals because. We said that there's not public notice.
Well, it would be if
That would
somebody
be on
didn't,
our judgment.
yeah, and if somebody didn't
Accept.
hear about a permit, because we know that they won't. But they hear through a meeting at the APC or the commissioners, or they see structures being erected, for whatever reason, discovery happens. Then we still will accept their appeal as long as it's made in good faith. They didn't just wait 2 years and then come appeal, and they didn't just hear rumors and come try and file an appeal on hearsay. They see some evidence or they hear it in a public setting that's official. And so they come to the county and they say, is there a permit for this action? And they say, well, we don't really get permits. We don't really do that. They can still have the right to make an appeal.
Mhm.
That's what we're saying here.
Mhm.
So if there was a permit issued. On 5,000 South, which doesn't exist, so it's hypothetical. A permit was issued on 5,000 South. Pursuant to Article 15, which again doesn't exist. Hypothetical,
Okay.
and then they see it being built.
Yeah.
They can now come 24 months later, because that's how long it took the industry or whatever that permit was for. 24 months has expired. And now the appeal can occur.
They can ask for an appeal. We don't have to grant it.
Yeah.
So then we need to have a rule in place of what we're going to threshold that we're going to use for good faith. What do we consider to be good faith?
Yeah.
Because I mean, it took 24 months for the said organization to create on 5,000 South. It took that time.
Mhm.
It went through the publicly noticed process because in order to. It had to be rezoned, so it had to get publicly noticed, it had to do this, it had to do that.
Mhm.
Because they didn't pay attention to their email.
Right.
Or they didn't go to coffee at the Chatterbox,
That,
then.
they actually
They
wouldn't
only-
get to
I
take,
understand good faith, but we have to have some
the
parameters.
only way that they get to take advantage of the good faith option is if it wasn't publicly noticed. So if there was public notice, then they don't get to take advantage of the good faith option.
Of the permit,
Like, if it was something big and it was publicly noticed, then it satisfies number 2. So it doesn't go on to the if no such filing or notice, because there was notice.
but if we're appealing a permit. Permit is being appealed. Person A comes to Fountain County and files with the planning office an appeal. For a permit, against a permit.
When this was first written.
So then the permit has never been publicly noticed, so then. The board may consider what is good faith, what is our criteria
And
of
so
good faith?
then that's on number 1, on the guidelines. And at this point, it's just left to the board's discretion. If we want to go further in future rules and define good faith, that's fine. There is a lot of precedent around good faith in court and in other law. Let's go to Michelle and see what she thinks about good faith. Can you tell us what that means? Are there criteria for good faith that we need to specify now, or is it something we can just use discretion on a case-by-case basis?
Courts use discretion on a case-by-case basis. You never want to define something like good faith. It's a very nebulous term, but courts haven't defined it, and I wouldn't undertake defining it. It normally just means that, it's left to the discretion of the decision maker, and it means that you're honest and, you have a good reason for the delay. It wasn't like you were dilatory and you slept on your rights. The court's concerned with, okay, I want to look at the facts and circumstances of the case before me and what this person is saying. And remember, the burden is on them to show it was good faith. So, it has to be some compelling reason why they feel like they can bring the appeal, and then you can decline. Also, remember too, as far as who can appeal is a whole other issue, right? Not anyone can appeal anything. You have to have certain stake or standing in order to appeal in the first place. So there's other guidelines too, but yeah, generally speaking, the law doesn't define things like good faith or reasonable. Those are words that are subjective, and the decision-making body or judge makes those calls. They're usually not defined. And for good reason too. You can't really put a definition on it, because if you do, it really caps you onto certain things. It'd be very hard to sit here and sort of speculate or hypothesis, come up with a different hypothesis for what the different realm of reasonable or good faith could be. We couldn't do it. It would be a kind of a useless exercise. The first time you tried to apply it, you'd be like, oh crap, we didn't think of that. So
So you mentioned is that not anybody can file. But second question, somewhat with that is so does this rule have retroactivity towards anything that may be a permit or may not be a permit of anything that may or may not be pending in the county of Fountain in the state of Indiana of the US of A?
you guys have to decide that, whether you want to put language in here about an effective date or what the cutoff is, or any of those things, right? This could be from this date forward. This could be silent on it, which I think would invite anything that's pending right now that might have been discovered. That's something that needs to be decided. Just like if you were going to pass a statute, some of them are effective immediately, some of them don't kick in until the future, some of them are completely silent about it. That's a decision that needs to be made.
I think what he meant was if there's already been a permit issued that's exceeded the 30-day timeline and we just don't have visibility on it, is this still capturing that? Are we even allowed to capture that? Is that right, John?
I'm wondering, right, just blanket retroactivity, like,
Yeah,
so now we say as of, I mean,
yeah.
9/22, I would hope we're not voting on this tonight, but If we were to say 9/22, as of X time that this is effective. Then we have, so if there was a permit for Article 6. Which is wind ordinance, if there was a permit out there, I'm using a what if. Now all of a sudden we can, this is the rule that applies for a permit that may or may not exist according to Article 6.
So the purpose of this is to make sure that we're capturing what I would characterize as phantom permits. Right now, phantom permits remove due process rights for the citizen of Fountain County. Our ordinance has gaps that created the possibility for phantom permits. So we have to have a way to still let those people who, by all rights, and even based on activities taken at public meetings, had every reason to believe that no true permit had been issued. If the zoning administrator chooses to retroactively grant a permit beyond 30 days in the past, we have to have a way that the citizen can still come and exercise that 30-day right in a reasonable manner. And so that we have to have a discovery clause. Anytime that you have new rules, it's smart to have some language about what you're going to do in the transition. So I do have some proposed language for that, but it would just basically, like, what I think might be handled best is, we know that appeals have been filed with the county. We haven't moved on them yet because we lack the rules to handle them. But we don't want those people's clock to time out either. So we may want to have something that we discuss, and we can do it at this meeting or at a future meeting where we allow people to refile if they filed during this, period of no rules with the BZA. And so that very well may mean that if the zoning administrator chose to retroactively by many months issue a permit, that would then need to come before the BZA. And then it would trigger number one for us on guidelines for determining whether an appealable action has occurred. We would have to sit down and say, okay, this is what's before us. This permit was issued, in 2014. Do we think that this is something that the BZA should hear? And then we would have to, weigh evidence and legal counsel on whether or not we should do that and make our decision.
Can I make a recommendation?
Mhm.
Cause we can nitpick this to death all night. I'd like to make a motion where we consider final to the change that you made and approve this as our starting point with changes to come in the future as needed. Because we still all have a lot of questions and we're gonna need her to answer those if we come across them. Because this gives us the guidelines started. And from there, we can build on it as we see fit as a group.
Right.
Because there are ambiguous little phrases in here all through this that we could pick on if we wanted to. I think we need just to get a starting point going and have a rule. So I'll make the motion.
Well, we still have the motion on the table that we're in discussion for, and I think I might be able to actually adapt language within that motion. Let me ask Michelle. Are you familiar, and can I go ahead and say that because of the discussion, we're gonna remove the finality clause and just invert that statement to say, we're not gonna consider the 30-day window to have begun until these criteria are met? Or do I need to rescind my motion and then have a new motion with the different language?
Cleanest way is to just have a whole new motion, although I've seen people throughout many board meetings revise or tweak the original motion. It's really up to you how you want to do it. We can withdraw that motion and then make a new motion and clean it up that way, which would be my preference.
Okay, so then I rescind my motion. And if you want to make the motion removing the finality clause and having it just begin the 30-day window, then you can do that, John.
Okay.
We got to be more specific about what we're removing, right? So what are we striking specifically? Let's Are we taking out, like I said, I think you could change it with one word, is not considered final, could become not considered appealable and keep that, or we could strike that whole thing. I mean, we need to be specific about what exactly we're putting through.
Okay, this,
And
this is what I would say. I would say the 30-day appeal period does not begin for any permit, order, requirement, decision, or determination until it has been filed, and then you go to number 1 and 2. So basically, instead of repeating a permit, order, requirement, or decision, we almost get rid of that entire first line about it
Okay.
being considered final, and we just go to the 30-day appeal period does not begin. So we're just defining the start point for the 30-day appeal period. And that way, we're not even like preloading what is appealable. We're still leaving that in the discretion of number 1. We're just saying we've got to have an instrument for determining when this 30-day window started. Because the state just says 30 days, but they don't say what triggers it. It just has to be within 30 days of the decision and determination, all of that. So then we're gonna say, we don't know about the 30 days until these criteria are met. If they're not met, because they're not required to be met, then we still are gonna give a good faith clause so that our citizens aren't disenfranchised.
So we're changing, we got these Monday morning. We've had 24 plus 12 hours, give or take. And we're making decisions for. Can we sit on these and think them through?
Well, I have some concern too. I know there's a motion, but I don't.
We
feel
don't
like-
have a
No,
motion.
we don't have any motion yet.
Okay, if this is a draft rules, I don't think we've even hit on who may file as a free person. I've had people reach out to me and say, who can file, cannot file, and I said, just call the commissioner, call me, right now, I cannot speak to that personally.
Mhm.
And so, like, they wanna know who, are we gonna specify an agreed person, property owner adjacent, or demonstrable interest? Are we gonna address those kind of things? The notice of appeal hearing, notice of conduct, this feels like this is still not sufficient.
I think that we began that process when we defined interested parties. But
It's just not.
That's interested parties,
It's
not
not
people that
clear.
can
That's
appeal.
just notification, yeah.
That's just-
who has standing is certainly something that we have to define.
Yes, but we didn't.
Right now, we're only dealing with the timeline and whether or not a decision was even appealable. But I am with you. We need language on who has standing to appeal. It is a huge question in the county. In fact, I would like to see us, one, have a full training session with Michelle, where we can get a lot more questions than this, just these answered. I think that it's not an undue burden to put on the county to make sure that we all have some more legal training on what our roles and responsibilities are. But we also could create guidance around an appeal that would go out to the county, or if they came here and had questions, that they would have like just an FAQ.
Yeah, exactly.
And it may even be inside our purview, once we're trained up a little better, because I don't feel ready to do this now, but to host an information session where people can come in a public way and have their questions answered, and we have legal counsel on hand. It's not that we're guiding anybody towards flipping decisions. We just want to create more transparency around the appeals process. But we do have appeals filed. And so we do have to address
Get filed.
in short order
Right.
when the 30-day window starts. We have to address that we may have ambiguity on permits in this county when they started, and that we're gonna still protect citizens' rights. So that's all that this really covers.
Their interests protected as well.
And
That very much.
So
But
then,
when we,
these are people that have been filed.
yeah, when we go to adopt tonight, everybody.
Who are these? So we haven't decided whether these people are aggrieved parties or people who can file on people.
Well, isn't that the motion that we made last week, the 600 feet?
That's interested parties. That's who's getting a notice, not who is a person that. I'm interested, well, I live within 6 miles, no, it's just who's getting notified.
Look, appeal situation is not even the only set of rules that we were supposed to have written before we even started doing business as the BZA. So I wrote these.
We're not.
This is my first crack at it. But of course, when we set it before the body, we figure out what the next steps are. So let's be willing to do that where we're on a roadmap towards getting the county, on the right side of this. But it doesn't necessarily undermine what we're doing here. We've had legal counsel review. She was shocked that we didn't even have this in place. We have to respond in some way to the appeals that were filed as best they could with the county with some form that they had that we don't even have transparency on. And we also have to create a provision to make sure that anybody that came in during that period before we had it ironed out doesn't fall through the cracks, that they have the right to refile and that we're going to consider that timely also.
So there's no disagreement that we need to have. We also have processes that have been given to us by powers that are higher than us. We mentioned having training, having the legal counsel there, that requires a budget that goes through the council, having all of these pieces, then the highest power in the county being the commissioners. What are the commissioners? That's a.
John, there is no
issue.
highest power because we have separate and distinct branches of government. So it's not that we have processes issued to us. This is our internal rules meeting. And they don't have to be approved by the commissioner.
But these are given to us by the ordinance, which is approved by the commissioners. So it says that we can establish the rules because that was established by the commissions in the zoning ordinance. I'm saying
Established by the state. We're just making sure that whatever is in those ordinances, that permits line up with that.
so.
Yes.
So having this in a, we talk about the past. We haven't had rules. We also have had times where we haven't had times that of the public even knowing what's going on. So in that, making sure, and then us being able to read this over, John's point of nitpicking, it's not a point of nitpicking, but being able to mold this over for more than 36 hours. Now we're changing the language. So in a matter of 20 minutes, we have to make a decision that's going to affect appeals, people's ability to appeal in a matter of 20 minutes. I think that we're being very hasty.
All I'm saying is it still needs more, like our ordinance is lacking, this still needs a few things, like. That's what I'm saying, are you making the motion that we just adopt this as the whole procedure for appeals?
This is
Or
for,
just a start?
this is a start. It's just for determining the time frame
Okay.
and for the BZA to have some guidelines, a starting point for us to be able to say, is this even an appealable decision?
Well, that has to include, is that an agreed person, like, do they fall into that criteria?
think
That's got to be.
As was stated to us by the council who controls the budget, let's get all of these together and send the package in order to get approved. Then we have time, then we have to.
Michelle, are we supposed to send our rules to get approved by the council before we meet?
No, that's here.
No, we.
Yeah, I have a question to the attorney.
Yeah, I mean, we don't believe that we're required to do that. It might be helpful to coordinate an overall effort if they're gonna tweak the ordinances to make sure everyone's on the same page, but procedurally speaking, we have to adopt rules and we don't necessarily need to share them. We could work with them. We might want to. We might also want to come up with more than just these rules. I don't know if we want to do a piecemeal. I'm over here thinking, is there a benefit to doing all of them and passing them all at once? One thing that just popped in my mind, unrelated but related, is, well, crap, if you guys are deciding the May language, is it a majority of you that decides, yes, we want to hear this appeal? So what is the number needed in order to decide that you will hear an appeal on the good faith thing? So that we need to probably consider. And I wonder if there's other things that we might need to mull over a little bit. But to answer your question, I don't think we're required to have another body look over the rules, and I would have to look into more. I mean, obviously, we don't want anyone swaying what the BZA does, and we got to be real careful about anything that looks like, I don't know, stacking the deck, if you will, and not being impartial. So I would want to be careful about that. I do think it makes sense to work together towards a common goal of getting the whole scheme fixed, ordinances and all, but I want to be careful about how we do that.
Point out that there are certain things that we find to be lacking and request that that goes through the right process. But as far as who is aggrieved and who has standing, that is actually already defined in the ordinance by the word affected, which could be anyone in the county. So right now, that is already set. If we want to make it tighter, then that's something that we can run through legal. But it's not that it doesn't exist. It's already in the ordinance. People who, I'll pull it up, people who are affected by a decision can appeal it. So that's already in there. The only reason that I think that we should do this now, piecemeal, is because we have appeals that we don't have anything to do with. And we have to be able to say, is there an appealable decision? What do we do if a permit was given retroactively? And what is the window? Because if we run out the clock, if we set the standard right now to be, well, we're gonna wait until we have a full package of rules prepared that covers absolutely every, angle that this could be taken at, we disenfranchise the people. We run out the clock from
No,
discovery.
there are still, we're gonna set ourselves up for problems for the county if we don't address other things that, like, right, I have side by side right now, what the rest of the appeals was saying that lacks some of these specific things. So I can't speak to that, just in my own research in general, what the draft rules for procedure appeals, like, it has authority and purpose, filing of appeals, you may file the form, like petitioner's personal name number, is it just one parcel, is it, how is the project to do this? There are all other nuances that I feel we still have to judge that, is it meet what the, the zoning requirements were. The time, of course, notice of appeal of hearing, conduct of the hearings, and then the decisions, like, I think you still have to say, this is what it'll be if you appeal, this is start to finish. And yeah, I mean, this is just two parts of what I think has to be determined, like, right by these rules for appeals. But like I said, I don't have pulled up what's already there for appeals. What's existing language now. I didn't spend any time with that this week.
Well, I mean, we can say as at the end of this meeting that we are on a roadmap towards refining our appeals rules to meet the ordinance requirements and to meet, legal concerns and to satisfy the state law.
And their BZA.
Yeah. But
That
if
has to be long drawn out.
But we should, I think, go ahead and decide on the timing. And make sure that there's room, because right now, it's still to the BZA's discretion in this thing. It's not setting out any new rule, still says it's gonna come before the BZA. And the BZA will decide, and BZA decisions are generally made by majority. I don't see why it would be any different than that.
That's a question I have. What if we've had cases before where we've had to continue things because we didn't have quorum, or
Or we have questions for the county, yeah.
then what happens in that case? Is the clock still ticking on that 30 days in that case?
As long as the appeal goes in the 30-day window. And right now, we don't have a way to decide whether or not the 30-day window has been done. So I don't think that we have to render our decision within 30 days.
Five.
No.
Okay, Michelle, Green.
Okay.
We do not have to render our decision within 30 days.
Okay.
But the people have to file within 30 days. And so we have to tell the county, like, The county knows that we have some permits that may have gone in retroactively. We have to let the county know that it's still a viable option, that Fountain County doesn't protect phantom permits. They still have a way to get their appeal in.
So then again, it sounds like we're making a rule about something that may be pending. So are we for sure making a rule about something pending? Or is this going into effect as of 9/22? So anything previous to 9/22, if voted upon, does this affect it? So if the phantom retroactive, whatever the terminology is that you use, is this affect that? Because if we change Article 6, and there's already something in Article 6, can't go back. They're held to the standard that was back then.
I do think that we need language for what to do during the transition. And I think it can just be as simple as we make a motion after this motion that we're gonna allow people who have already filed to refile, and we're still gonna consider it timely.
So now we're having more motions, back to my point of we've
There
had-
is a sense of urgency though, because we do need to make sure that people get notified of the procedure before the 30-day window runs out. So I get that it's pressure. You know, I had to,
whether pressure
See,
or
but
not,
it's
it's not
so
a thing
I
of
don't-
pressure. But you talked about transparency and having for people, and so now we're now making decisions of what's appealable, time frame of appealable. We don't even have who's defining who's the party of it. So they're affected, so then person in Wallace can appeal what happened in Portland Arch. What do we mean by affected? So then.
that's why there is, anytime, we're not gonna go through the whole appeal process until we do number one. Or when we get an appeal, we sit down as a body and say, was this even appealable? And right now it is open-ended and it's left to our discretion, but so are many things.
So then why are we not hearing the appeal since it's up to us and then we weigh the appeal out on its merit?
Say again?
You said we have appeals on file, which I didn't know. So I found out tonight we have appeals on file. So we have appeals on file, you're saying. So now we're making decisions about appeals that are on file.
Well,
So why didn't we-
everybody knows as soon as they came through, and that's why we needed to meet and discuss
Because we
interested
got,
parties.
that we had appeals. You said we may have potential appeals. I did not know that we had appeals.
Well, it's not for me to say what is a viable appeal. We have to have the rules for it. So, I mean, you can pick apart my language or my order of operations on there. But this is a rule that starts to give order to the chaos. It's not the end all be all. We can come back and we can make adjustments as needed. And there are safety valves built in throughout this that leave it to the discretion of the BZA. And the BZA is deemed to be a trustworthy body by the county.
So that's what my point of, why don't we then have the appeals come before us? Since we have that discretion that's already in that, and then we sit and think through all of these in more than 36 hours, or now we're going to have a motion about what is gonna happen in the interim, so we have even shorter amount of time. So we
We
can,
don't have to do the transition period one right now, but we are not allowed to hear appeals. The BZA in Fountain County has never heard an appeal. The things that we have heard were variance of use. No,
I don't think variances, yeah.
we have heard variances. We've never had anyone come in and appeal a decision.
Yeah.
We are not allowed to hear
Haven't
appeals.
been given for most for things, like, so, you know, like.
Yeah, but to answer the question, why can't we just hear the appeal? We can't hear the appeal because we don't have rules on appeals.
Yeah.
So we have to start.
Some language, right, because that can really open up some.
And I'm not even comfortable hitting go on interested parties. Until we know that the 30-day window is somewhere reasonable.
That's all our.
Well, that's the thing, then we have no guidelines at all.
Well, this is the start, but this, like, all I'm saying is this isn't hitting on all the things that should be in it, that's all, and that's what I'm saying, it's just, it's like the third part of. I think just a few more, yeah, but I think we've already talked about who, you know, is the interested party, just who gets notification. And then the time frame, and then permits, like, there's a lot here. Yeah, I think there's a few things missing, that's all I'm saying, but yes, I agree, like, there's already things in motion and. These things should have already been done, so now we have to do them.
Okay, let's see if we can hear anything to help round us out from Michelle.
Yes.
So I'm a little flabbergasted at that the county has never heard an appeal, and I'm super nervous about touching anything without rules, right? I mean, we need to have rules before we do anything. And the public needs to know those rules, right? So I'll give you an example. I have fought developments on behalf of the people who remonstrate against them before, and I've had to go through the appellate process. And as a lawyer, I need to know what are the rules. So Marion County, one of the biggest counties around, has substantial administrative rules in a huge packet for just about everything. So, I mean, we need to get there where Fountain County has a packet of rules too. And you all can decide what rules you like or you don't like. You could look at other counties' rules, but we have to do something to get something going. And if nothing else tonight, we need to at least commit to, we got to start doing this. And we can maybe decide what rules are most important. I don't think that we're going to be able to launch a comprehensive set very quickly, but it sounds like time might be of the essence because there's appeals. I don't know that we need to do anything with those appeals at the moment, because once they're filed, that's sort of the date they're filed, and that will never change for purposes of considering whether they're timely. Nothing the BZA does will change that. So those are kind of on hold. But those people are going to want to hear back from the county at some point, and we need to make sure we've got procedures. So, I mean, you all can decide whether you're comfortable passing this as some sort of, stopgap until there's more rules or till we get to kick it around more, or you want to wait. I mean, I guess I'll say this, the rule as it is now, I know that there's things that people don't like about it, but from my perspective, it's legally harmless, right? I don't think that disaster is going to strike if we pass this tonight. But I could also see, maybe ironing out some details if people still have concerns. I mean, it's really not my call.
I don't think that there were details inside this that were the concern. It was more that this just sort of indicates how much we lack. And there are other elements that we lack, but we lack elements on quite a few subjects from the state. And my personal opinion is that we need to go ahead and give guidance on how we're interpreting the ordinance and the state law together. As when does the 30-day window start? And is everything appealable? No, we have to have a threshold that says the BZA is gonna look at this. If we're gonna give a safety valve and say, you can let us know when you discovered the action, because we know that they weren't notified any other way. We have to have a safety valve on the other side that prevents abuse of that. And that is how this is built. So there's logical bookends everywhere you look in this rule. And it shows that the BZA is doing its due diligence to deal with its delinquency on having rules. Because now we're sort of caught with our pants down. We have an appeal in the office, and we don't have rules for dealing with appeals. So that's why this is as built as general as it is, but it deals with some really important questions. When does the 30 days start? What do we do if there's this phantom type of permit where it's retroactively given? And how do we decide if it's appealable? Well, it comes before the BZA. So I don't think that really adds to or takes away from anything that's done. It just starts to do the business of being a BZA, which is to build a foundation.
So based on this tonight, that you're presenting, you don't feel like we could now hear appeals to you?
No, we cannot.
Okay.
hear appeals yet.
I'm just saying based on what, yes.
Yeah.
Okay.
Remind me what motion is on the floor.
We do not have a motion. We decided to go ahead and have a talk about what we were gonna strike.
Okay.
So if you're looking at, the appeal language, you could just start a line from on the top line and go all the way out to the 30-day appeal period. The 30-day appeal period does not begin until the permit, order, requirement, decision, or determination has been. Then we would hope that they would let somebody know. And then we know that that doesn't happen sometimes, so we have a safety valve built in with our good faith clause. And that is only to establish when the state law gets triggered, because the state law is set in stone, it's 30 days. And then we're gonna have guidelines for determining whether the appealable action has even happened. And it just comes to the feet of the BZA again, that we're not trying to like create some arbitrary infrastructure out there that we would have to have really ironed out. We're just saying, we don't know until we see it right now.
So has that been, is Michelle, are you saying, can you say that the item's not under legal review number 2? Publicly noticed, and it says, note, this item is still pending legal review.
I don't know if you were here for the top of the meeting when I sort of addressed that. I looked into that more and kicked it around and decided that I didn't want to tweak that language any further and just wanted to leave it as is right now, because I think that the way it is now is what I'm comfortable with, and I don't want to make a bigger mess about it, because the notice issue is tricky based on what kind of action it is, because a decision or an order gets noticed when it's going through, but a determination by, say, a zoning administrator isn't going to be something that's noticed. So I wanted to leave that one sort of open, right? So if the zoning administrator decides, for instance, not to enforce a ordinance, how the heck would the public know that in order to file an appeal? So that, I don't know, that was my concern about what notice looks like. And I don't know the answer to that question, so I don't have anything to add about what the best. I can't improve upon the language that's in there. I guess that's what I'm saying. But that is an area that's a problem. Unmute yourself, Jess.
I was just making sure that we weren't going to read into the motion something that was still pending legal review. So if she's good with it. So you're saying it's the motion. So move that the 30-day appeal period does not begin until the permanent order, requirement, decision, or determination has been, 1, filed with the county planning and zoning office in the ordinary course of record keeping, and 2, publicly noticed in a manner reasonably calculated to inform affected parties consistent with applicable law and BZA rules. If no such filing or notice exists, the board may consider appeals made in good faith that are filed within 30 days of the appellant discovering the permit, order, requirement, decision, or determination.
Mhm. And then it goes on, these guidelines would also be part of the new rule. And we didn't talk about number 2 or 3, so let's do that briefly before we go on. We've talked a lot about number 1.
That was moved.
Oh, I didn't hear you make a motion. You were making a
I
motion.
was moving that for that case. Isn't that what we're doing?
I'd like to go cover, to me, it's a whole package. It needs to be worked together, so I'd like to cover number 2 and 3 before we hear the motion. So number 1 under guidelines would be,
So I would move so you're wanting me to remove I'm confused.
I didn't hear you make a motion. Did you make a motion?
Yes, I was making a motion of,
You just said move.
I moved
Move that.
Oh,
the
okay,
appeal period, I was moving that. I thought that's what we were doing.
okay. Do I hear a second to John's motion? To handle just the first part?
I'm processing.
If not, we're just gonna look at it as one package.
Yeah, I don't have a problem with that, but just that part. I don't mind considering either, just, I'm not gonna second it, we just can consider the rest of the thing, it's wonderful.
So you want to remove notes 1 and 2?
No.
No, we just.
Okay, well, hang on, we have a motion on the table for just considering the time frame portion of the appeal.
He was just doing this.
Yes.
My motion is for the rule, to adopt the rule, the 30-day appeal period does not begin until the permit. Order requirement, decision, or determination has been, 1, filed with the county planning zoning office in the ordinary course of record keeping, and 2, publicly noticed in a manner reasonably calculated to inform the affected parties consistent with applicable law and BZA rules. If no such filing or notice exists, the board may consider appeals made in good faith that are filed within 30 days of the appellant discovering the permit, order requirement, decision, or determination.
Okay, I'll second that.
Yeah.
That was the rule.
Do we have any other discussion before we vote on time frame? Okay, all in favor? Say aye. Aye. Okay, let the record show that the time frame and the criteria rules 1 and 2. And also the if and such filing clause passed. And now we have the guidelines for determining whether the appealable action has occurred. Let me just introduce those to you guys before we go on. Okay, the problem with leaving it only at time frame is that we do have ambiguity in the way things are done. So I felt that it was really important that we go ahead and when we say time frame, that we build in a companion rule for any ambiguous or disputed decisions. So here's what I have. Since the board may be confronted with ambiguity in some of the appeals, I've put together a companion rule that would help the BZA determine whether an appealable decision has actually been made. Because, you know, if something was ambiguous from the zoning administrator, we would need to see, like, did anything final from your end ever go out? So here's why I would, here's the arguments I would make for you guys for this companion rule. So number 1, the Indiana statute on appeals says appeals are permitted from any order, requirement, decision, or determination from the zoning administrator or other body. But for the appeal to be valid, according to state law, there has to be a clear, identifiable decision. So ambiguity undermines the statute's intent by making it impossible for citizens to exercise their rights to appeal. So there is a requirement in Indiana state law that Fountain County be clear about whether or not something was appealed. And we can't affect the ordinance. We all know that the ordinance needs work, but that's not this body's job. So all we can do is work with what we have, and I think the best thing to do is handle that on a case-by-case basis. So that's where number 1 comes from. Also, in the United States Constitution and the Indiana Constitution, there are due process principles built in. So citizens must have notice and an opportunity to be heard when a government action affects their property rights. That's built into all of the Constitution. So we have to make sure that we are making sure that that stays intact. If those records are absent, right now, the board can't just presume that a decision happened to undermine those. We have to build something in. Also, Indiana courts recognize a good faith standard. They rely on good faith to show that citizens are acting reasonably based on the information that's been made available to them. So that's why there's 2 triggers. Okay, so the only reason that I feel like we really need to move forward on that is because we know that we have been accused of litigation or threatened of litigation because of having ad hoc procedures. So this helps to formalize some of those procedures and make sure that we're on strong legal footing. The actual guidelines, number 1, when an appeal is filed and there's ambiguity or a dispute about whether an appealable action has occurred, the Board of Zoning and Appeals shall first determine whether a permit, order, requirement, decision, or determination even exists. Well, how would we do that? Number two, the zoning administrator or any other issuing authority, because if it was like, say, a commissioner's decision, that's all in the public sphere. So this is really kind of related more to county staff, just as best as I can conceive of it. The zoning administrator or any other issuing authority must provide documentary evidence of the permit, order, requirement, decision, or determination, including the date of filing in the public record. And then we have our if clause. So that's what we would hope, if we got an appeal, we would hope that a permit would just show up and we would be able to say, oh, sorry, people, this was noticed and you're outside your window. But we have to care for the ambiguity right now. So we have another if clause, just like we had an if safety valve in the first one. The if clause says, if no such documentation is produced, the board may determine, not shall determine, may determine that no valid permit, order, requirement, decision, or determination exists, and therefore the time period for filing an appeal has not begun. So if we get an appeal, and then we say to the zoning administrator, like, hey, you know, what happened and when, and there's no evidence of any proper decision, then we have to say, sorry, there's no appealable decision here. Now, what does that mean practically? Well, if somebody's building a data center and then they appeal it and they come to the BZA and we say, sorry, there's nothing here to appeal. Well, then there's other courses of action that that person could go and take, but they have to complete their process in the appellate realm before any other actions can begin. Number 4, appeals filed in good faith based on reasonable belief. So those are those 2 sets of things that she said she wouldn't touch with the 10-foot pole because they need to have room. Appeals filed in good faith based on reasonable belief that an appealable action has occurred, including but not limited to the commencement of construction, official correspondence, or public statements, may be accepted by the board until the threshold question of whether a valid permit, order, requirement, decision, or determination exists is resolved. So that just gives us some criteria to start with. Does it have to be where it ends? No. If Marion County's is this big, then I'm sure there's more to it than that. But it gives us a good foundation, and because of the way it's worded with language like may and good faith, then it's open-ended enough that we're not putting the county in legal harm's way. You know, we're protecting ourselves and we're doing our due diligence and creating the internal rule.
So in number 2, we can compel testimony already. So number 2 is just saying that we can compel testimony. But then it says that including the date of filing in public record. So if there's not a process in place right now, that the zoning administrator files in public record a permit, order, requirement, or decision or determination. Number 2, they can't provide that.
Right.
So then number 3 kicks in, since no such documentation can be produced.
Right.
The board can then determine that our permit's not valid.
It may, yeah. There may be other reasons to think that it was valid. But it does give the board the authority to say, if we don't see any documentation, because I think some permits for projects did get taken to the county, but some haven't. So if the permit doesn't exist anywhere that they can produce and they can't show where they filed it anywhere, then the board has the discretion to say, well, sorry, we don't see this as appealable. You're gonna have to go another route.
So if number 2 doesn't exist because of the process that is currently in place. Now the board, being the BZA, now has the ability to determine that no valid permit exists.
Correct.
So,
No valid appealable decision.
so then the person that's appealing is out of luck, or the person that received what they believed was the permit is now out of luck.
Well, I think the way it would flow, and I haven't researched this very much, but if they go to the BZA and the BZA says, sorry, there's nothing appealable here, then their next course of action would probably be to go to the commissioners and say, hey, we were told there's no appealable action, and yet we have this reason to believe that these processes are underway. And then, like, let's say that they were halfway into build, or they had started building the data center for the hypothetical, not real thing. Then the commissioners could refer for enforcement that, hey, you're building this without a permit. Does that make sense?
But there was a permit that was, but it wasn't, there wasn't filed in the public record.
I
So
see what you're saying.
it never has been.
It's just this filing in the public record line. That's the problem.
So if he, and I'm using that in the general, the zoning administrator provides that document. That's where I'm saying is I think we need to get together with having that the processes, which we can't affect on the BZA, get looked at by the people that can affect, being a zoning administrator, being the council, because the council has to, and to Michelle's point, not stacking the deck, I agree, but they can say, we can't spend that amount of money. We have budgetary constraints. So where do they want to put their money at in order to make this happen? So getting all of these pieces in order to be able to provide for these things. Instead of us opening up, this wording opens us up. So then any permit, order, requirement, so if the zoning administrator says you have to have a commercial level septic system, and he doesn't put that into public record, we can say there's no valid permit.
Well, we have to look at the way it's written in number 3. Number 3 says, if no such documentation is produced. I would be fine with saying, including the date of filing in the public record if available. But it's not. The number 3 isn't based on whether or not it was filed in the public record. Number 3 is based on if the documentation is produced at all.
Well, doesn't it go by if the application is complete? And whatever, like top drainage piles, flood things, that goes more to, instead of us saying specifics, I think it's if the application was found to be incomplete and it was passed.
Well, that would
Then
only
that's
be,
the thing we would say.
that would be in the body of the appeal. So this isn't looking at the merit of the decision itself to give the permit. This is just trying to decide if an appealable thing even is there. And so what it's asking is whoever issued it has to provide some kind of documentary evidence that they issued that decision. I agree, it's a good catch that by making it including the date of filing without any conditions there, that might pinch it in too hard because we know that there's no date of filing. So it's just if no such documentation is produced. So if we go back to the data center hypothetical, if somebody appeals that decision and the zoning administrator can come in and say, well, look, here's the email I sent them that I told them should serve as their permit. That would be the documentation. Would it have public filing included? No, but that's not the threshold for number 3. Number 3 is just if no such documentation exists, then the board may decide.
So if they produce that requirement that they gave, they give, here's a list of A, B, C, D through A, B, B, C, C, whatever. And they provide that to us, then that's good enough for us. That's the permit or decision or requirement or determination.
If the zoning administrator, it's just one thing that has to happen.
Agreed.
Yeah.
I'm not disagreeing that it has to happen. I'm saying is.
But I don't know that I would say if they produce whatever documentation they produce, it doesn't mean that just because they handed something in that it's automatically an appealable decision. We would still have to look at what they hand in and see if it meets the criteria of the ordinance.
So if we get an appeal in, doesn't mean at the appeal, because it rules for time frame. So if it doesn't meet the time frame, then we can kick it out.
Mhm,
If it does meet the time frame, we can keep it in.
mhm.
If it doesn't meet the criteria for documentation, we can kick it out. If it meets it, we can keep it in.
Hmm.
That's,
I
So
think, I think so, I think yes.
that's what I'm just trying to.
Let's see if Michelle wants to weigh in now. Michelle, do you want to weigh in on that?
Yeah, I mean, that's generally what it does, right? We may do this, we may do that. A lot of it's going to be discretionary calls based on what we get back. And there's really no magic to it. It's what did one judge say about the definition of porn? I know it when I see it, right? I mean, we'll know when it's something that we can handle or not, hopefully.
With the concern of having on number 2, that last bit, including the data filing and the public record. We know that some are not filed anywhere in the public record. Does that cut us off by having that included in a list that way? Do we need to have like an if available in parentheses?
Wait, one more time. Which line are you talking about with the public record down?
Number two under guidelines.
Okay.
There were some concerns because it says including the date of filing in the public record. And if they didn't file in the public record, does that automatically kick it out, how it's worded there?
Yeah, I mean, I think we could reword that and have it be, must provide. And then, any documentary evidence of the permit, including but not limited to the permit, the order, right? I would add something that said must provide documentary evidence of the, and then say including but not limited to, and then list permit, order, requirement, because there might be something else that isn't in that list too, and we don't want to make it to be all of those things. So I think I would do that. I'd stick in including but not limited to, and then just list, take out including the date and put date of filing in the public record. Because we want all the information we could possibly get, but we don't know exactly what we're going to get. And we don't want to accidentally exclude something, and we don't want to accidentally require something that may be non-existent.
So in speaking hypothetically again, since we love doing that on evenings after 7 p.m. Does this, if we need to get from a county engineer, does number 2 cover that? So if we need to see engineering specs, so the issuing authority, can we get those specs? Because if they're supposed to require, if there's a requirement to meet certain engineering specifications, that would weigh in on some appeals. Does that make, you see what I'm saying? Does that cover that, Michelle?
If we
Although
put
it may not
including but not
necessarily-
limited to, and issuing authority. I guess, John, are you asking if issuing authority includes the town engineer hypothetically?
Yes.
I think
I was
that's ambiguous. I think zoning administrator or issuing authority,
We could even say,
County engineer, county
and or
highway.
the ordinance likes the phrase, and or
appropriate
appropriate.
staff.
So we could
Yeah.
say, and any appropriate county staff where anybody can be compelled to show evidence of the decision.
So if we have in the future, a road use ordinance, which would touch the county highway department greatly. Does number 2 cover that? Or do we need to look at that? That's, I'm just making sure, so we don't exclude ourselves or include ourselves or exclude or include or include or exclude. I should be aware.
Yeah.
I think the word requirement, doesn't that cover that? Are you saying like you were saying specifics?
He was
Does the
saying-
requirement address that?
He was saying right now, the only 2 people that we're saying must provide documentary evidence are the zoning administrator and whoever this issuing authority is.
Right.
Does that box us in too much? Or is it too broad?
I go to Jason and say, hey, if appeals come in, he goes, well, it doesn't say in rule number 2. I'm not saying Jason would do that, I'm not
Yeah.
imputing Jason, I'm saying this rule number 2, he's our county highway guy.
It depends on if they're an issuing authority. I think what we might run into if we go with county staff is that you might have a deferral of the burden So if there's a long list of who could provide the evidence, then it might be that some of the players inside that could say, oh, she's giving us a big nod. Go ahead, Michelle.
Yeah, absolutely. I think I've already maybe seen a situation where someone claimed they were just a contractor and they couldn't do XYZ hypothetically. I think it's important to not have the list be too long because then everyone will kick the can down the road and say it's not them and they can't give the information to us. So that is a problem too. We almost have to specifically list people, but I also don't want to leave anybody out.
We need to make a number 5. In order to say, but we can compel testimony, that's a pretty big
Well,
catch-all.
that's gonna be the
You
rules for
say
inside an appeal.
Yeah, yeah.
So this is only deciding if we're gonna even have an appeal. We
Yeah,
have to
this is
have a
just threshold
package.
stuff.
Have it to-
Yeah. That's.
I just wanna be
That's
able
a
to get,
whole other booklet of rules about the actual procedure.
We wanna be able to compel testimony, we wanna have teeth. When it comes to compelling testimony, we wanna be able to request documentation. I want Michelle to be able to depose them in private session, but that probably won't happen. So,
with chains and whips.
but Michelle, I have not told them about that email. I just don't want to step out of my lane. But is it okay for me to update them in a public way on the status of that documentation request?
Well, I mean, I think it was relevant to some of the pending appeals to just sort of see what evidence. And I guess I'm interpreting that question that you asked as you trying to figure out the timeliness issue, which is germane to what we're doing here. So I think
Mhm.
it would be a nice illustration of why this is necessary to share that.
Okay, this isn't to sway anybody's future decision, this is informative only. But when I got word that people had come and filed appeals, the biggest issue I could see was that there was no permit. And so I just went to the zoning administrator, not as a BZA member, but I actually invoked the Information Act of Indiana and said, we'd like the permit, please, according to this. And I was told that he was just a contractor and that I should try and go through a proper process to get the documents. And I responded with that I was referring to him in his capacity as zoning administrator, that the same authority he used to issue permits also made him responsible for managing records. And I have not heard back.
Nothing.
Yeah. So that's why this is named so specifically. We have to have a way to compel whoever has the authority for Fountain County to give permits to reveal them to the county government, so.
Jessica, could we add county engineer or other issuing authorities?
Sure. I don't see any reason why we couldn't name county engineer, right?
Names that we hear this position referred to.
But the only problem with naming somebody else is that you may have a person say, well, you could have gone through them for this. It doesn't necessarily say it has to be me. So I don't think that the county engineer right now has the authority to issue any permits. The county engineer stamps, the county engineer creates designs, but the only one that's issuing permits
Okay.
is.
We're not just after permits, we're after orders, requirements, decisions, or determination.
Well, that's why I think we have to stick with whoever issued it. It's their responsibility. So zoning administrator or other issuing authority, I think gives enough protection to say, if you were the one that sent a permit or made the decision, whoever issued it, you're the one that has to provide some kind of evidence.
But what if the decision
To the
is that
BZA.
the road is torn up too much?
What do you mean by that, Dawn?
So in some of our ordinance, it says is that if the road is, I can't remember exact wording. But it says that there's a road use, clause. So that would not be that would be the county highway determinant. That's what I was asking, is that the issuing authority of the determination? So then we think if the county highway is the one that drives down 5,000 south and says, oh, too many potholes. You have a cease and desist order until you fix the potholes. Yeah,
I think it might, I don't think we actually manage highways in the ordinance.
No, but maybe it's just where these requirements in the permit being granted, like like. That would still fall in, if someone comes and says, I can't drive down my street, like, I don't even know how to feel that, but.
What I'm saying is if there's construction being involved and that there's required to be a road use plan.
Right.
And then it says that if you tear up the county road, the county can issue a cease and a cease work order, stop work until the road is fixed. That company or that person who or company that got the permit can appeal that, and I believe it would come to us. So I'm wondering does this, then if we need to, because I believe it's the county highway.
I think it would, John, because they would still be the issuing authority of
And that's
that
fine.
decision.
I'm not saying he doesn't, I'm just trying to ensure that it does, not
Yeah,
that, I'm not.
because we wanna provide coverage on both sides, right? It's not anti-business. If a business gets a decision from the county that they disagree with, then they need to have a recourse for that too. I actually have a personal anecdote.
I know that's kind of the point, but if we had a building inspector, that would be their responsibility. Okay.
Yeah, and
So-
there's also enforcement provisions where they may actually, need to be taking that
Right now,
up.
that's basically commissioners.
Yeah, I think that might land on the commissioner's desk.
So then if there, so for instance, if a company comes to Fountain County. And says they want to get a permit for X, Y, or Z,
Mhm.
and they don't get the permit. Their first course of action, how I understand it.
To
would-
appeal not getting approved, you mean?
Yes.
Yeah, because the decision would still be coming from the whoever to not get their
So
permit.
they didn't get a permit, so then we would have to hear it
Mhm,
if they were to file an appeal.
mhm.
I'm just trying to, not saying it doesn't, I'm just trying to think of all the sides of the, by touching the tusk of the elephant, the leg of the elephant, think of it from all sides as we describe this.
How about this? Instead of saying or any other issuing authority. Instead of saying any other, why don't we say the zoning administrator or the issuing authority of, and then list all the decisions that we could be hearing. And that way it's not like this guy or any of these other guys. We could nail it down a little bit more. Specific.
I'm not sure that we want to narrow it down with too much, because who is the enforcement? I mean, we're the appeal, and we have the judgment to make, but so does APC, so does the commissioner, so does the council. There are a lot of people input throughout the whole process.
If they violate us with the BZA, then we can refer it to the county authority, county attorney.
Right.
We can say is you violated our order, because we said that appeal was granted, but they say, I'm gonna continue building. Or however, whatever that,
Right.
we then say, hold on a second. We said this is what it is, then we can refer that to.
Then we
the
pass
county.
Right, and I mean, so. I kind of agree with Michelle, leaving it vague is probably a good decision.
It's like a wider net.
Yeah,
And
because.
as long as we have the right
everything's
things.
clear cut anyway.
Mhm. But I did make the change, including but not limited to. So here's how number 2 would read now. The zoning administrator or any other issuing authority must provide documentary evidence, including but not limited to the date of filing in the public record. Oh, I'm sorry, documentary evidence of the permit, order, requirement, decision, or determination, including but not limited to the date of filing in the public record.
I thought you said it was gonna be if available.
Well, she struck my if available idea and said, including but not limited to instead.
Okay.
I put the including but not limited to in front of that list, right? So must provide documentary evidence including but not limited to permit order requirement, and then put, date of filing in the public record. So
Can I say any permit or the permit? The permit order requirement or determination under consideration?
I wouldn't put under consideration, just, yeah, and I maybe put any permit order requirement decision.
How do you
I think it has
file
to
an
be
appeal of
the,
it?
because we're looking at it being, was it an appealable decision or appealable permit?
Right.
So they have to provide evidence of the appeal, because we're referencing the same thread all
Right,
along.
in this matter, yeah, not just any old permit.
Yeah, not any old. Do we even need date of filing in the public record on this thing?
Hmm. Well,
But not limited to, so.
yeah, I mean, we kind of want to know for time frame purposes how long this thing's been going on, right?
Oh, yeah, so it's just gonna be another thing in the list.
They
So-
should be file marking everything that they do. And when we take appeals, on a related note, we need to be file marking it. I don't know if we are, but like, for instance, if it was filed in 9 of 2025, it should be like 9/2025 dash, and then whatever the case number is. We need a marking system too.
I'm gonna make that note and the things that we want to consider in the future along with who has standing.
Lots of fun stuff. I actually sent you a couple examples of what these things look like in their final form from some smaller counties, not just the Marion County Beast. So you can kind of see what these things look like when they're done.
Okay, let me read this to you again and see if it meets muster. Okay, the zoning, let me make sure I'm not gonna read it. Determination. And, I need an and at the end, I think, not an and or. The zoning administrator or any other issuing authority must provide documentary evidence, including but not limited to the permit, order, requirement, decision, or determination, and the date of filing in the public record.
Sounds good.
Okay. Okay, and then, okay, so we have another including but not limited to in our number 4. Just giving some things that we might consider a reason to want to file an appeal if you haven't been notified any other way. Maybe acceptable, maybe accepted by the board. I'm sorry, let me start at the beginning of number 4. Appeals filed in good faith based on reasonable belief that an appealable action has occurred, including but not limited to commencement of construction, official correspondence, or public statements, may be accepted by the board until the threshold question of whether a valid permit, order, requirement, decision, or determination exists is resolved. Does that last one make sense? Good, solid.
Seems pretty
Yes.
broad.
Seems pretty what, John?
Seems very broad.
Seems very broad. Yeah.
So if the commencement of construction,
Well, the commencement of construction is just an example of why they would have a reasonable belief that some appealable action has occurred, even if there was no public notice. It's basically
Evidence.
defining
Evidence,
good faith.
yeah, they can appeal.
Yeah.
There's.
So it's telling the people of the county like, hey, you can file an appeal even if you didn't see a permit, as long as you have a reasonable, reason to determine that there was something happening that you even could appeal. And then it gives some examples, like maybe it should say IE instead of including but not limited to, but it could say, for example, commencement of construction, official correspondence, or public statements. I think it's just safer legally to say including but not limited to. Because they can't say, well, look, you gave these examples and now they're using something completely unrelated.
That's right. You don't want to, that's the legal term of art, including but not limited to.
And then again, it does not compel the board. It just says that it may be accepted by the board until the threshold question. So until the board gets to see whatever evidence the issuing authority is going to produce or not produce. Okay. Well, that's my introduction of those. So I'll go ahead and make a motion that we adopt the guidelines for determining whether an appealable action has occurred, given the changes to number 2. And did we change anything else? Nope, just that was the only change, the one that we went over with Michelle. So I'll make that motion.
I'll second it.
Okay, any discussion? Further discussion? I know we have discussed it. Okay. All right, then, with no other discussion, we'll take the vote. All in favor, say aye. Aye. All opposed?
So I'll abstain from the second.
I'm sorry, what, John?
I'm gonna abstain.
Abstain. Okay, let the record show that we had 4 in favor and 1 abstention. Let me just say, before we go, that we do still have a long road ahead, a lot more administrative work than I think any of us knew was gonna be on our plates when we took this on. For right now, we can just keep our regularly scheduled monthly meeting. I am gonna hammer away at drafting more rules, but you are all welcome to do the same. If you want to access legal counsel on any of those and get them looked at, just forward them to me and I'll forward them on to her and keep you copied and keep you in the loop. We just have to be really mindful that we're not deciding anything behind the scenes. All of the deciding has to be done right out front.
Yeah.
We
Jessica, could you forward those that Michelle sent to you of the smaller counties? So we could get an idea of what we're even looking at, so we had time to consider it.
Yeah, that's a good idea. And then we do have those 2 appeals. There are 2 appeals that got filed with the county. I don't have any experience looking at appeals, and we really had to figure out if there was anything even to appeal. And my effort to get documentation on that fell flat. But at least now we have some good faith safety valves for the citizens. I would like to see our next steps being to keep focusing on the appeal process, because we know it's what's next and it needs to be really, it needs to have a lot of rigor in how it's developed. But also to have our eye on what we can do to start answering the public's questions about that, whether it just be communications that are put out on the county website. But if it's possible, I would like to eventually work towards letting the public come in and ask some questions. As long as we stay in our lane and we're not talking about any future decisions, I would imagine that that would be safe. And then I'd also like for us to look at having a training session with Michelle. Maybe that would just be a special meeting. I think we are allowed to have certain kinds of closed door meetings. And I did recently find that the BZA can write its own budget. It is connected to the APC's budget in a state law, but it's by like a very wobbly thread. The state does still give BZAs the authority to write their own budget. So if we're going to do things like training or anything like that, then it's probably a good idea to put a package together and let the council know what we're thinking so that they can weigh in on that kind of spending before we proceed. So
Then our next meeting will be October the 21st.
check the site. We have some that are already
Yes.
notified. Is that right?
Yeah.
Did we do the minutes from last month?
You have a copy of them there, but we're gonna wait to approve them until everybody's had a chance to review them.
Because there was there's something that wasn't correct.
In the minutes.
So the motion that I made, it was property owner and residents whose land within 600 feet. Not just property owner.
Okay, we'll have to look at that. But yes, October 21st would be the next meeting, Tuesday, October 21st. Unless we figure out that we need to have something sooner. And so looking forward, we want to, one, consider a training for the BZA. Two, consider writing out a budget so that the council knows what we're thinking for that.
Council's already in the midst of a budget, so it's not gonna be probably, I'm just guessing they're in the midst of hammering out the budget by October the whatever, so probably won't be till 2027.
Okay. We'll have to see what our deadlines are on them.
To the price.
Number three, I think that we need to make sure that we produce some kind of transition language to let people know that they're still considered timely, even though we're working on these rules, so some kind of statement about that or rule about that. Something about our transition time. And number four, I think we're just gonna be working on finalizing our appeals process. And hopefully we'll have a good one that Michelle said that we can just base it on as a starting point. We're not starting from scratch. So I think it was important that we kind of started from scratch here since we have some definite gaps in the ordinance that wouldn't necessarily fit what's going on in other counties. But hopefully everything else is more straightforward.
Yeah, the
does any-
the procedural stuff for how to conduct hearings will be very, we'll be able to use that stuff, but there's some unique to Fountain County things that I think it was good that you just did specific to this, because other counties don't have this issue.
That we know of.
Okay, does anybody have anything else?
Do we approve these minutes by like literally signing them and giving them back to you?
No, we'll make a motion to approve minutes at the next meeting and we'll just do we just tabled that for now.
Don told me about a correction, I need to add residents.
Yeah, so just look over them and if you have anything, just let Day know. Anything else? Well, Michelle, I am so glad we made time to be with us tonight. Thank you so much. And
Thanks.
everybody here is nodding their head. I don't know if you can see them, but we all really, really, really appreciate it. And with that, I'll make a motion to adjourn. All in favor? Thanks, Michelle.
Talk to you later.